There are some provisions in the Criminal Jurisdiction Ordinance that provide for certain crimes or certain crimes that have an extraterritorial effect. Now, if one is to look at the Criminal Jurisdiction Ordinance, they also have, well, there are actually generally two areas by which an exception could be created. First, when it deals with implementing international multilateral conventions, then extraterritorial jurisdictions may be exercised. Secondly, is where there is a certain part of the Act, either the whole or a part of it is happens in Hong Kong, in other words, the relevant act that the court has to look at, then the criminal courts in Hong Kong may have jurisdiction. So in the context of looking at whether one should simply amend the legislation to include extraterritorial acts to become a criminal law in Hong Kong, one has to look at the retrospectivity point that I mentioned. In other words, if you are creating an offense, effectively stating that the court has jurisdiction to deal with the particular acts which is actually committed outside of Hong Kong, in the criminal courts in Hong Kong, you will actually be creating a situation whereby the criminal law jurisdiction is now extended to an offense that did not exist at the time of the legislation. In other words, it cannot assist the one of the factors that the Secretary for Security has said, and that is to deal with the Taiwan murder case that happened last year, because the law cannot have retrospectivity. And one cannot have retrospectivity because it goes back to our Bill of Rights, Article 12.